Good. We've got some more attendees. Welcome, everyone. Welcome. This is the Golden Gate University Office of Student Life presentation on the U.S. Constitution, Origins and Evolution. And today we have some special guests, Laura Cisneros and Craig Jackson, and there are constitutional law aficionados today. And they will be presenting a little history, a little current events interpretations. Um, Q&A is open. Please ask questions. Type your questions into the Q&A, and we have two sections where we will ask them. All right. Laura, I'm going to hand it off to you.
All right. Well, welcome everybody. Good afternoon, and welcome to GGU's Constitution Day presentation. I would like to thank the university and Jennifer Rupert for organizing this event. I'm Dr. Laura Cisneros. I am an affiliated scholar at the University of San Francisco School of Law, and before that, I spent more than 16 years teaching constitutional law, and most of that at Golden Gate University. My work focuses on constitutional theory and interpretation with special attention to how the Supreme Court uses history and memory to shape our sense of time and equality. I'm delighted today to be joined by my distinguished colleague, who I have worked with over the years, Professor Craig Jackson from Thurgood Marshall School of Law at Texas Southern University. Professor Jackson is a distinguished scholar of international law, U.S. foreign policy, and constitutional law. His work spans critical issues from national security to immigration, with particular insight into how constitutional principles interact with international legal frameworks. So together we will explore how words written in the 18th century continue to shape 21st century life, and ask why knowing the Constitution matters for all of us as citizens. So let's go ahead and get started. And I am going to share my screen here. Okay, that's up. Okay, so today, September 17th, marks the 238th anniversary of the Constitution of the United States. On this date in 1787, 39 delegates gathered in Philadelphia's Independence Hall to sign the U.S. Constitution, ending months of intense debate about how to structure a new republic. That document, ratified by the required 9 states by June 1788, was made effective in 1789, created the framework of government that we live under today. So Constitution Day reminds us that our constitutional system didn't emerge fully formed. It was crafted through compromise, it was shaped through experience, and it continues to evolve through interpretation and practice. And as we face contemporary challenges that the founders could never have imagined, from digital surveillance to global pandemics to social media regulation, understanding constitutional principles becomes more crucial than ever. So whether you're concerned about immigration, education, digital privacy, climate policy, voting rights, the balance of power between the federal government and the states, constitutional principles provide that analytical framework for understanding these issues. So today what I'd like to talk about is just give a very brief introduction and provide some historical context, then talk about what a constitution is, then a little bit of structure of the American constitutional law in the current moment, and then maybe a little bit of a projection and a looking forward in terms of constitutional law's future, and then end with some concluding thoughts. So why study constitutional law today? There are a number of reasons, right? In terms of our current constitutional moment, we are reminded of January 6, 2021, and questions of constitutional resilience, right? How our Constitution has been tested over time, most recently in 2021, in terms of looking at things like how the document and our fidelity to it deals with questions of and issues of political norms breaking down. January 6th was one of those events and moments that revealed what happens when these customs and these democratic norms start to collapse and start to erode. Um, Institutional legitimacy is also tested in these kinds of critical moments. When significant portions of the population question the legitimacy of elections, of courts, or of government itself, then constitutional authority itself becomes fragile. We also see these moments as instances where violence enters into politics. Uh, Typically, the Constitution assumes that political competition occurs through debate and voting and not through threats or physical violence against officials or democratic processes. And so moments like this kind of reveal some of those fissures. And then finally, partisan constitutional interpretation. When constitutional meaning becomes purely partisan, with each side claiming that the Constitution supports only their own positions, then the document itself loses its role as a shared foundation of law. Second reason why studying constitutional law today makes sense in our current constitutional moment is because of recent Supreme Court decisions. These recent decisions have reshaped federal-state relationships. There's been a shift in authority from federal to state governments, reversing decades of federal supremacy in certain areas like reproductive rights and substantive due process. We have also seen recent Supreme Court decisions that have limited executive agency power. Creating doctrines like the major questions doctrine that require Congress to clearly and specifically authorize significant federal regulatory actions that administrative agencies rely on a certain amount of flexibility in terms of creating processes and procedures. We have also seen the tension and conflict arise between constitutional rights and state authority. So cases like gun control cases, New York Rifle Association versus Bruin, show that there is this tension between expanding individual constitutional rights in terms of concealed carry laws, in terms of the leniency of background checks with respect to gun regulation. So this tension between expanding individual constitutional rights and traditional state police powers that had historically been able to regulate in those particular areas. So a lot of recent Supreme Court cases have demonstrated a reshaping of what that allocation of power between the federal government and the state government is. Uh, Finally, the digital age that we are in and continue to progress in creates challenges to working with and applying an 18th century framework that we have with the document itself. Concepts like privacy, when we talk about law enforcement searches, that was originally thought of as physical searches of property and persons. And now we are having to rethink what those rights and protections mean when law enforcement is using digital surveillance or data collection or tracking cell phones. Looking at changes to free speech uses, right? Moving from things like the town square and auditoriums to social media algorithms or content moderation or online harassment, right? Different types of forums in which these rights are being exercised. With respect to elections, moving from paper ballots and ballot boxes to things like social media disinformation and electronic voting, digital voter registration, all of these things that bring up different aspects of the relationship between government regulation and protection of individual rights. So For a brief, everything you wanted to know about constitutional history in under 3 minutes, from King to Constitution, we have our timeline here just to set the basic grounding for the documents that we are talking about as being foundational. So obviously, the English colonies in North America started off. Some of the colonies were organized as companies. Some of them were organized under royal charters from the King of England. Some of them had royal governors appointed to it. Georgia was, in fact, a penal colony. But at this moment in 1776, we get the colonies coming together to form a delegation to the Continental Congress and draft the Declaration of Independence, which signaled a desire to come together and pursue a collective solution as a collective body against the monarchy, as opposed to each individual charter, each individual colony trying to separately seek independence. This ends up with independence and revolution, and our first attempt at being a union was the Articles of Confederation and Perpetual Union between the states in 1781. Now, this was uh, um, almost like a league, like a federation, like a treaty among equals. The states were all independent under the Articles of Confederation. The overriding understanding was that the sovereignty and the power to govern the people rested with the states themselves, not with the citizens. Each state had one vote, and so every decision had to be unanimous. Congress had no power to tax or regulate commerce. There was no executive considered in the Articles of Confederation, and there was no national judiciary. So under that system, there were some strengths and some weaknesses, especially in light of the inability to raise money, the inability to come to unanimity when dealing with decisions about commerce among the states and with foreign nations. In 1787, we get the Constitution adopted, drafted in 1787 and ratified in 1789, where the document and the founders plug those holes. They create a Congress under Article 1, they create a presidency and an executive under Article 2, and they create a national judiciary under Article 3 in order to create this centralized government with the ability to make decisions for the states as a whole, as a nation. So, what is a constitution and why would a new and changing country actually want one? Well, there's a couple of reasons, and there's a couple of things that the Constitution, in effect, actually does. And so, some of the reasons that are given here are having a legally written document tends to create a gravitas and a seriousness of the creation of the moment, and a baseline setting for the creation of the nation. It's something that can be popularly validated, which it was ratified by the states. It is something that can entrench a structure so that the government can actually operate. And it is also a place to put limits in so that everyone has an accountability check, and the government has clear ideas and structures in terms of what its powers are and what its limitations are. It creates this agency of public power so that states that are unable to deal with situations on their own because of size, because of money, because of resources, can pull together under the federal government umbrella and deal with situations and issues on a larger scale. And it tends to limit the influence of raw social political power, right? If you have a large enough system and you have the rules and regulations kind of written down, it allows for accountability and tangible oversight and checking. So even with our document in place, even with our structure of government solidified, we've seen moments in our past where constitutional resilience has been called upon, right? How constitutions survive crises. So we've seen under the Civil War how the Constitution survived and attempted secession through legal and military responses. And the reaction to that was to expand the Constitution by adding the Reconstruction Amendments, the 13th, 14th, and 15th Amendment, rather than replacing the entire framework altogether. In the Great Depression in the 1930s, we saw the New Deal presidency and New Deal legislation kind of stretch constitutional interpretation. Powers that Congress has, like the Commerce Clause or the power to spend federal money, those powers were read much more broadly to give the federal government the ability to deal with situations brought on by the Great Depression. And so we get a maintenance of the institutional structure again, but informal expansion through interpretation. Likewise with 9/11 and the 9/11 response, right? Under 9/11, after 9/11, we see emergency powers being expanded. We saw entrees into surveillance and detention in the immediate aftermath of 9/11 and curtailment of civil rights. But to the extent those pushed constitutional bounds, courts eventually imposed limits on executive overreach. So we get an overcorrection of security and safety at the expense of liberty, but then a moment in time where the court does eventually start to impose limits on that overreach. So again, an informal expansion of executive power through interpretation of the document itself. So, okay. Oh, okay. So we have some current stress tests, obviously, in the current moment that we are in. Polarization and the effects of extreme political partisanship. We have institutional trust in decline, where we have questions about election legitimacy. We have questions about court decisions, and we have just kind of an overall democratic norm erosion. Things that had been dealt with between the political branches and among all three branches in a very kind of soft power, customary democratic norm way are being highlighted as issues of extreme tension in this moment that we're in now. One of the constitutional law professors, I think Professor Tischnet from Harvard and Georgetown, called this the branches playing constitutional hardball, right? Rather than softly working within those blurred spaces of shared power among the branches, we get an extreme overreach and extreme commitment to encroachments of power. And so the key difference between these three constitutional crises that I have up here and the moment that we're in now is that previous crises tested constitutional capacity, like what the Constitution could and did hold. The current crisis, to me, as I see it, is in effect testing constitutional legitimacy itself. And so it falls to the citizenry to kind of figure out and distinguish what is normal constitutional disagreement versus what is a bona fide constitutional crisis. So the structure of American constitutional law, there's three core functions. One, obviously, to create a national government. Two, to define the federal-state relationship and this allocation of shared power between the federal government and the state governments, and to limit government power to protect individual rights. And on that basis, that's where we get the ideas and the concepts of separation of powers and American federalism, which gives us that coordinated and mixed government system that we are seeing in our current moment kind of being challenged and being tested. So some contemporary federalism tensions, contemporary conflicts between the federal government and the state governments are being experienced with regard to a number of issues. Election administration, federal oversight versus state control of voting procedures, polling access, voter ID requirements, drawing of congressional district maps. So there's a lot of issues and questions arising in terms of the allocation of power between the federal government and the states with respect to election administration. Immigration enforcement, as we have seen, we get the conflict and tension between so-called sanctuary cities refusing federal cooperation versus states that are demanding federal action, and the militarization of domestic law enforcement. We also see as another area environmental regulation, where state climate policies are conflicting with federal energy standards and priorities regarding climate regulation. We've seen some things recently where the EPA has proposed rolling back key climate change policies and eliminating mandatory reporting of greenhouse gas emissions, and those kinds of things. And then finally, reproductive healthcare and healthcare in general. So post the reproductive choice decision, Dobbs, states are actively kind of conflicting with federal agencies over everything from medication access to federal agency guidance and even interstate travel. So we have this shift in how this federalism relationship is affecting the issues and concerns that are touching most of us in our daily lives. So, how do we think through these conflicts? Constitutional law has at its core a very basic analytical framework that asks two core questions. The first core question is, does the government have power to act? The federal government can only exercise power that is granted to it in the document itself. If there's no indication of the legislative branch or the executive branch or the judicial branch at the federal level being able to do something in the Constitution, then they do not have the power to do it, right? They don't just have a general federal police power to write laws and enact policies based on policy preferences. There has to be something in the document itself. The second core question then is the action prohibited by the Constitution, right? So first is identifying whether the government actor has the power to act. And second is looking to see if there's something in the document itself that is prohibiting the action. Some protection of free speech, a protection of free exercise of religion, a protection of the right to bear arms. Is there something in the document itself that is constraining the government's ability to act? So, constitutional law in our current moment is undergoing some changes. I'll say, to put it lightly, undergoing some changes. And I'd like to highlight a couple changes and then talk about some contemporary constitutional challenges. So the first is the Supreme Court's interpretive revolution. So what we're seeing from the court now is a shift toward a much more textualist and a much more rigid originalist interpretation, meaning that it is very backward looking to a fixed historical moment in time in the 18th century. And it is very narrowly and literally looking at the words of statutes and the words in the Constitution itself, looking at the words themselves as opposed to any type of substantive intent behind the statutory action or behind the constitutional principle that's being protected. So there's a much narrower view of what the Constitution is saying and what that saying comports for what the Constitution actually means. The second thing is the shadow docket and emergency orders. Now, there's been a lot of information about the court's reliance on what's known as its shadow docket and its issuance of emergency orders. The court has had a so-called shadow docket for a very, very long time. The shadow docket is essentially a process by which a litigant can essentially jump the queue, right? Jump the line. They can, instead of going through the regular appellate process, which is long and drawn out and deliberate, they submit an application, an emergency application for the Supreme Court to hear the case before it's been fully developed, before it's gone through the entire appellate process. And traditionally, when cases come up to the Supreme Court, there is a full briefing on both sides. Um, um, Arguing the narrow issue and question that the court needs to decide. There's oral argument based on that full briefing. There are signed opinions by the justices with a uh, uh, rationalization and explanation for why they are deciding what they're deciding, what cases they are relying on to make that decision, and explaining the decision that they have come to. On the shadow docket, what we get with emergency orders are oftentimes unsigned. And by that, I mean that they are not identified by name of a particular justice. Um, Always they can be, but they don't have to be. And there is little to no explanation in terms of the rationale that the court is using to render its decision. So you get a fragment of the court's decision, yes or no, without a lot of guidance or explanation in terms of the why that is underlying the decision. So the constitutional concern here with this increase abuse of the shadow docket and emergency orders is that there have been major policy changes that are taking place without the traditional deliberative process and explanation. And so there is created a tension between this request for emergency relief and democratic transparency. And then with respect to contemporary constitutional challenges, this kind of leads us into and kind of sets out the context for the cases that we are going to start to see more of um, beginning with this term, right? We've already seen a number of cases about executive power expansion and the emergencies power scope of the president, and what impact that has on congressional oversight versus executive privilege. And so there's been a lot of reorienting about the balance of power between the two political branches. We've seen recent applications of expanded executive power with federal deployment of the National Guard, immigration enforcement priorities, and emergency declarations, for example, using national emergency powers to direct military funding or implement travel restrictions or activate federal response capabilities. And so all of these things, which would traditionally go through a more deliberative process, the timing has been compressed. We've also, in terms of contemporary constitutional challenges, voting rights and election standards, as I mentioned earlier, are coming to the fore. Climate change and federal regulatory power. And then I was thinking about this earlier today. Artificial intelligence and constitutional rights is something that we can maybe start to think about as well. When we think about the possibility of AI systems making parole or sentencing or hiring decisions, how does that impact um, the application of the Equal Protection Clause or anti-discrimination statutes? So there's a lot that this court is going to need to deal with in the immediate and not too distant future. And so getting a process and a procedure in place that allows for democratic transparency is something that I'm hopeful for. So looking forward, we have some questions about constitutional law's future. How does or how can an 18th century text address 21st century problems? how might the structure and role of government be reimagined? We're seeing a number of government actors make overtures in reorienting what that structure looks like. So obviously, we know it's going to be different, but um, what might some of those differences be, and how can we start to think about shaping them in a way that makes sense? And then finally, kind of how to maintain democratic legitimacy in polarized times. We're at this moment where debate and political competition is really hard to have with not even just with just strangers, but with family and friends, right? So, how do we talk to each other and in terms of thinking about democracy and democratic legitimacy in this kind of time? So the court's October term is coming up. They open up for hearing new cases beginning the first Monday in October. They have about 30-ish cases on their docket so far. The last few years, they have hit upon, I want to say, around 80, between 80 and 90 cases, maybe. So there's going to be a lot more coming up on the docket over the next month or so. But here are some just to kind of take a look at. We've got a case about presidential power. There are two consolidated cases that are going to take a look at the question of the constitutionality of the president's authority to levy tariffs on nearly all goods that are imported into the United States by virtue of an executive order. We also have a case about voting rights that has to do with a redistricting map that was drawn in the state of Louisiana. And then we have two cases that are dealing with healthcare and equal protection equal protection. Two cases, Little versus Hecox and West Virginia versus BPJ, which are both taking a look at the constitutionality of state bans on transgender women and girls in sports. Little versus Hecox, I believe, is a college level athlete, and West Virginia is dealing with a middle school athlete. And then Childs versus Salazar is a First Amendment challenge to Colorado's statutory ban on conversion therapy. So that is going to be implicating some free speech issues to determine whether conversion therapy is considered conduct and healthcare, or whether it is considered a viewpoint and protected as an idea under free speech. So, part of our roles as citizens then is to try and kind of understand constitutional principles for the purpose of civic engagement, recognizing constitutional arguments in political discourse, and participating in democratic processes that shape constitutional meaning. So, just to leave you with some things to maybe think about and take away, the Constitution, it creates a framework, right? It is a blueprint. It is not something that gives specific and detailed answers. And it is up to us to kind of figure out how we should balance history and tradition with contemporary needs. And when you look at the court over the long haul, the court has gone back and forth in terms of how broadly or how narrowly. And so trying to figure out where we sit in a comfortable position with that is something that we should think about. Also, understanding that the Supreme Court is a storyteller, right? They are drafting and crafting the story of ourselves as a nation, but their legitimacy comes from the shared narrative that we build about who we are as a political community, right? The Supreme Court doesn't have the power of the purse. It doesn't have the power of enforcement of the sword of the army. Its legitimacy relies on its own credibility. And so this idea of creating a shared narrative in order to tell the story of who we are as a nation. thinking of the Constitution as a living conversation. Every single act of civic participation contributes to constitutional meaning making. Anything that you do and engage with is something that gets added to that shared history. And the importance of constitutional literacy. I think more than any other moment in recent history, it is crucial the role that citizens have to be able to distinguish constitutional disagreement from a constitutional crisis and get back to that ability to discuss and debate opposing ideas without losing trust, losing legitimacy, or shutting down. So I just want to leave you with a quote that I saw in novelist Margaret Atwood in her book, The Handmaid's Tale, where she says, "That was when they suspended the Constitution. They said it would be temporary. There wasn't even any rioting in the streets. People stayed home at night watching television, looking for some direction." And to that, I would just say freedom requires vigilance and engagement and participation. Even if it seems like you're not moving the needle, everything we do is actually having an impact. So thank you so much for your attention. And if we wanted to, were we going to open it up for some questions, Jennifer, if you had any?
Yeah, so there were no questions typed. We do have a hand raised. I would like to remind all attendees that this is an informational panel and it's really not meant to be a divisive kind of conversation. We are looking for information about Constitution, constitutional law. We will get into how it affects current events with Professor Jackson in just a moment. Um, for, are you, Laura, are you okay if I allow this raised hand to talk?
I mean, sure,
Okay,
we can
um,
see what we have.
all righty. So our iPhone participant, if you would like to ask a question, maybe not.
We can go ahead and save it to the end,
Okay.
since there's just one. So let me go ahead and invite Professor Jackson into the conversation to share his perspective about our current constitutional moment and thoughts on what we've been discussing.
It's always nice to take things off mute before you start talking to people. I will say that we just had a course in constitutional law in 30 minutes. It can save me a lot of time and get possibly get more rest if I just show this in my class. But it was a very great presentation. I would say that there are a couple of themes that you mentioned I really wanted to talk about before I got into some of this current events. One of my big and what I find one of the more interesting issues in constitutional history is this continued controversy over federalism, over where the line is drawn between state and federal power. You mentioned the goals and the aspirations of the new air quotes new Constitution in 1787. Um, but it also it was still fairly undecided among a lot of Americans after 1789, when the Constitution went into effect, whether or not we had a nation. Um, people still had allegiance to their state. Today, allegiance to one state is more like a football game. I'm an Alabama fan, or I'm a Texas Longhorn fan, that sort of thing. Or um, but then it really was almost like a nationalistic thing. You're a Virginian, or you are an Alabamian, or a Georgian, or you are a Southerner. And in fact, the whole idea of nationhood was so much that even our language was changed. We people referred to the United States as a plural noun well into the 18th, 19th century. And it took a civil war before we started thinking of the United States completely as a singular noun, one country, not however many countries there existed during the Civil War, but one country. And it took the Civil War amendments to do that. And then the debate as to federalism still goes on. We still have not figured out the parameters of state rights versus federal authority to this day. We still have controversies about that. So that's the federalism issue, far from being easily determinable in our constitutional debate, is one that just is not going to go away. I don't see how it goes away at all. Every time something comes up, states' rights or it's federalism, it's one of those things we have to expect to be a continued part of our constitutional debate. Um, as far as current events, the three biggest issues for me have to do with three cases that I think have that had to do with the issue of uh, deference to the executive on the part of the Supreme Court, which is basically another way of putting it, executive power. Last year's immunity case, Trump versus the United States. This year's birthright citizenship case, Trump versus Casa, and most recently, last month's Noam versus Perdomo. And basically, these cases have to do with executive power or executive deference to the executive. And I gotta say, I think that the Supreme Court got it wrong in all three cases. Trump versus U.S. was a fully fledged decision. It was a case about basically whether or not a former president, which is what Donald Trump was at the time, a former president, um, can be prosecuted for criminal behavior. And the court said no. And then it laid out some reasons or some categories of possible liability, criminal liability, leaving basically the criminal prosecutors on such cases with one rather narrow area where a former president can be prosecuted in matters having nothing to do with any kind of presidential power or authority. Um, it was a flawed case. It was a case that went against the tide of history. I don't think any president before the current president really thought that there was immunity. I know Richard Nixon didn't think so, and Gerald Ford didn't think so. That's why Gerald Ford pardoned Richard Nixon. But all of a sudden, we get this new idea of immunity. That's an executive matter of executive deference that I think the court got wrong. Another case that I think it got wrong this year, last summer, was the Trump versus Casa case, the birthright citizenship case. There are a couple of things that go almost without saying. The Constitution says it. That's what it is, and that's what we've been told. Typically by members of the court who would consider themselves and who the rest of the country considered to be rather conservative, that you have to follow the text of the Constitution. Original understanding, textualism, these kinds of things. Well, the 14th Amendment says what it says, that people born under the jurisdiction of the United States are considered citizens who are born in the United States. The executive order that came out beginning of this year that would raise questions about birthright citizenship has not been heard totally by the Supreme Court. We'll make that very clear. But what has been heard is something you mentioned from the shadow dockets, so to speak. In other words, an emergency order to undercut lower courts' decisions to prevent the federal government from enforcing the executive order denying birthright citizenship status to persons born in the United States to parents who are not citizens. Basically, approved the president's executive order nationwide, and this was the issue in this shadow docket matter. Now, the reason why the court gave for restricting the ability of the lower courts to put out a national injunction against the use of the executive order to deny birthright citizenship status to persons is because the reason why they did so, where the lower courts did so, is because it's patently unconstitutional. Constitution says birthright citizenship and it is what it is. There is a case that would have to be overruled in order for that executive order to be considered constitutional. So what the lower courts were trying to do was to prevent the United States from pursuing a patently unconstitutional principle nationwide until the matter can be decided on the merits in total, which could take 2 years. Now, a lot of people are going to be denied birthright citizenship in those states where that were not parties to this litigation, or individuals who are not parties to the litigation. A lot of folks are going to be denied birthright citizenship status to their detriment and might get deported in the process. That's a problem. And that's not even a complete case. The decision will not be made until a couple of years from now. And then there's the most recent case, Nome versus Perdomo. Racial profiling. Are you kidding me? That also was a shadow docket case. The reason why it's a shadow docket case and why the court made a decision. Well, I don't really know why the court made a decision because they didn't give any reasons. The only reasons we got were from a concurrence by Justice Kavanaugh that basically said that we have to respect the right of the government. We have to understand the possibility of irreparable harm to their immigration policy. The problem is the irreparable harm is ostensibly in violation of a decision of the Supreme Court from the 1970s, 1975. You do not racially profile. So there can be no harm, no legitimate harm to a policy that has been ruled to be unconstitutional. These are matters that trouble me, to say the very least. And they're essentially deferential to the executive branch. And that's a problem. Whether we call it a constitutional crisis yet, I don't know. But these are the directions that the court is going. Now, whether or not the shadow docket cases like Trump versus Casa and Perdomo, Nome versus Perdomo, are representative of how the merits phase of the decision is likely to come out, I don't know. I think there's probably some data on that. I'm sure in the research by various scholars who've looked at this have examined this closely, but I haven't. So I don't really know if that's a precursor. Or can we expect the merits phase of these cases to come through the way the shadow docket phase of the case has? Nonetheless, it's something of concern. And basically, I just there's so much more to talk. We can maybe have a discussion about that.
There we go. I was going to ask Jennifer if there were any questions. If not, then Craig and I could just continue a discussion. And if a question comes up, then please feel free to interrupt us.
You're on mute, Jennifer.
I think you're on mute, Jennifer.
All right, I'm going to change our view to gallery.
Okay.
So that we can see everybody. Go. Okay. And well, I think we do have a raised hand. That will be Matilda Fritz. Matilda?
Hello, hello. I wanted to ask you a question about the shadow docket and to the extent that it's meant to affect the lower courts, what does that mean for setting precedent for cases that might come up in a similar context or concern? How does that affect maybe cases that come up surrounding that litigation or external to?
Well, Laura is more of an expert on the shadow docket than I am. But I will tell you, the last shadow docket decision was Nome versus Perdomo. There is no opinion. There is no opinion in that case, just the decision. Only thing we got was a concurrence by Justice Kavanaugh and a dissent by Justice Sotomayor that was joined by Justices Jackson and Kagan. But we don't have an opinion by the majority in Nome versus Perdomo, so they can't. It's hard to get any precedent out of that.
Yeah, Matilda, I thank you for your question. Yeah, Professor Jackson's kind of pointed out one of the biggest problems about the shadow docket in the fact that they don't have explanatory reasoning. So one, it kind of occludes democratic accountability and transparency because we don't know why these decisions are being made. But two, on a more practical level, it doesn't give any real guidance to the lower courts. So the precedential value of decisions rendered on the shadow docket varies with the varies kind of in relation to the substance of the opinion that the court puts out. If it's just a thumbs up or thumbs down, it's hard to read what the precedential value of that is without knowing why the court decided it outside of the facts of that one particular case. So the entire concept of the shadow docket and the emergency orders, it has a massive impact for precedent and constitutional evolution. And as I mentioned earlier, the shadow docket is something that the court has always had. And the term shadow wasn't originally meant to be nefarious in any way. It has grown into something a bit more nefarious in the sense of how we have seen the increase in its use and the parties who are using it to maximal effect. So yeah, so in terms of like the specific precedential value, it's hard to say because, as Professor Jackson said, a lot of these opinions don't have any information really in them.
Right.
That's wild that they don't have to give any rationale for it. But thank you for answering my question. I've been enjoying this lecture very much.
Well, that's been one of the disappointing things. I mean, I'm a court watcher from way back. And that's been one of the disappointing things for me about this. I mean, I've been studying the court for a number of years and, shocker, not all the decisions are, I'm not aligned with all of the decisions that the court makes. But at the very least, you could count on having the rationale to work through and deconstruct and see where the strengths are in order to add to your own thinking and challenge and kind of use your critical thinking on where the weaknesses are. And what the court seems to be doing now is just it's just very disappointing because it is making a accelerated shift in how we do constitutional law and what that means without without a lot of explanation. I just kind of feel like I'm holding on to the back end of a bumper for a lot of this.
Yeah, I guess one of the questions I would have is just how presidential, even those shadow docket cases, and just explain because everybody doesn't have a legal training. Shadow docket is basically when someone appeals an interlocutory decision by a lower court, such as a court decides to enjoin the whole country. One single judge decides to enjoin the whole country, the president from doing certain things nationwide, which is the case in Trump versus Casa. It's not a merits decision. It's basically more of a procedural matter, but it gets to be handled immediately because it's an emergency. That's why. That's why they have them. That's the whole idea behind it. The question is what? One, is everything an emergency? The court has to decide and be a little bit more a little bit less generous when it comes down to acknowledging emergencies. And secondly, it does have, I think the understanding or the belief that many people have is that these shadow docket decisions don't have lasting effects. Like I explained in Trump versus Casa, people are going to be denied birthright citizenship status in those areas that weren't part of, in those areas and by those and to those individuals that aren't part of the litigation, they're going to be denied birthright citizenship status, which could affect their ability to stay in this country. So that's a substantive result of that. Now, the way to get around it, of course, is to a class action a suit. That's a procedural rule that could be made. But Justice Alito in Trump versus Casa cautioned, said, "Oh, by the way, we're going to be watching those class actions really closely now." So that's kind of like a warning, so that class actions won't be that prevalent going forward. So these cases do have significant substantive effect that may be overturned if the Supreme Court decides that the Constitution says what it means when it says birthright citizenship. But then again, who knows with this court? They may decide that there is a technicality that in that this case, Juan Kim Ark, United States versus Juan Kim Ark from 1898, was actually wrong and overruled it. Who knows?
We do have another question from Jessica Bride. I was curious about your thoughts around the discussions about growing the size of the court, and also whether there should be term limits for the justices.
Courts or term limits.
Laura,
Greg?
you're in England there.
So, I mean, I think that both of those, are interesting ideas. And they've certainly been ideas that we've kind of seen enter the political discourse every so often. Growing the size of the court. It's sat comfortably at 9 for quite a long time. I think what has it gone down to? Is it 6 that it's gone down to in terms of number, but it's never gotten higher than 9? I guess my thought in this moment with respect to growing the size of the court is that without fixing some of these other judicial behaviors first, like the increased use of the emergency docket, issuing orders without explanation, not having full briefing, right? So without fixing some of these judicial behaviors first, my sense of it is that simply increasing the size of the court really isn't going to do anything, because you'll just put on a bunch of justices from the opposite party, and then they'll make their decisions, and that's going to impact the next political president that comes in, and that they're going to like increase. If we increased it to 15, why not 17? If 17, why not 9? So to me, it doesn't really seem like there's an end game there with respect to just simply increasing the size of the court, because I think that would, at least in this political moment, transform the court into even more of a political advisory council body than it's currently acting at. In terms of growing the size of the court, in terms of term limits, there's some case language and some statutory language that would be challenging, I think, in terms of imposing term limits. I know that there's been a discussion when this was discussed during the Biden's administration. So there's a valid argument to indicate that imposing term limits on justices because the Constitution allows them to serve for good behavior might not be constitutionally feasible. But again, that's open to interpretation.
Yeah, I'm inclined to think that would require an amendment to the Constitution, and our Constitution does not amend very easily. Yeah, we had an amendment that took 200 years to go through. Hit at University of Texas, my alma mater, discovered it in 1980 something, that had been left just dormant since 1794, I think it was, having to do with paying congresspersons not allowing congresspersons to vote on increasing salaries or something like that. And the Equal Rights Amendment never got passed. So it's hard to amend this Constitution. And in terms of the term limits on justices, that would take a constitutional amendment. I'm pretty convinced, and I just don't see how that's even possible. under the current under the current system, but even under a system that's like that Franklin Roosevelt had in 1937 when he tried to pack the court. He had a Democratic Congress, and the Democratic Congress told Franklin Roosevelt, a Democrat, no, we're not doing this, buddy. So he had to back down from his own party. So there was historically been a lot of resistance to tampering with the size of the court, and I think we might not be able to do that.
All right. I want to thank you both, Laura, Craig, for being here, and for our participants, our attendees, for taking the time out of the day and learning a little something about the Constitution and constitutional law. This is our time. We are now at 1:00. Any parting thoughts that you would like to leave us with, Laura or Craig?
Craig, you want to go first?
Well, I think we should be diligent. We should watch carefully these developments. We should demand from not just the judiciary branch, but from the other two branches, what we call the political branches, that they follow the Constitution. That this is not a game where you try to outflank people with regard to the meaning of the Constitution. The Constitution has gone through many changes. It was a flawed document to begin with because it enshrined slavery for a long time, but it also had certain values that and certain principles that sometimes seem to be run roughshod over, and perhaps that kind of political strategy needs to be reconsidered.
Yeah, I'm a glass half full kind of person. So I am cautiously optimistic. Again, as a historian, I think as a historian, I kind of take the long view. So we've had troubling times before in different ways. But it's really going to take a mind shift to commit to the constitutional system, and to, as Craig was saying, to kind of be vigilant and to engage and be aware of it, rather than just being either celebratory or shocked and outraged.
All right. Everybody, thank you very much for celebrating Constitution Day with us here today. And Laura
Thank you, Jennifer.
and Craig, thank you so much for your time today. We really appreciate it.
Yes.
Have a great day, everyone.
Bye.
Bye.